Good morning, everybody. Thank you so much for being here. My name is JC Cortez. I'm the Director of Training and Development here at Synergia's Metropolitan Parent Center. Before we get started, we want to let you know that we're broadcasting this today via Facebook Live. So hello to the Facebook attendees. Thank you so much for joining us. Warm welcome. If you have any questions and you're joining us via Facebook, please place your comments or questions in the comments section. But yes, we'll be watching those throughout the presentation. But yes, hi. So I am with Synergia's Metropolitan Parent Center, and we're located in Manhattan, East Harlem to be specifically. And we are a multi-service agency that's been supporting New Yorkers with disabilities and their families for more than 40 years. We offer a rich source of information and training tailored for parents, including parents whose primary language is not English or who they themselves have special training needs. We help them participate more effectively in their children's education and development, and we partner with professionals and policymakers like we have today to improve outcomes for all children with disabilities. Synergia, which is Spanish for synergy, is one of New York City's 3 federally funded parent centers serving people with disabilities and their families with an added focus on communities of color and the economically disadvantaged. We help support them with a number of different types of programming, including parenting classes for adult parents with intellectual disabilities and parenting and education advocacy training for parents of children with disabilities. A few housekeeping notes before we get started. This meeting is being recorded and will be shared with you at the end of this presentation in case you have to leave us. I will also, be sharing the PowerPoint, so you'll get to see that too. If you have any questions at any time, this is a kind of a heavy topic and it's a lot of information to unpack. I will say, try and save your questions for the end, but if you have something that's about the immediate process that we can use clarification on, I'll definitely be facilitating that. So please feel free to ask them at any time. If you need further explanation or clarification on a question, please don't hesitate to ask. We want you to leave here at least with more information than what you came in with and have a better understanding. For the sake of privacy, I do have to reiterate, please, this is on Facebook, this is being on the internet. So if it's a private matter in case specific, then maybe hold off those questions and ask them specifically to our presenter, or you can send them to myself. But yes, try not to, if it's about the process, that's a whole different story and we're happy to answer those questions. But if it is case specific, for the sake of privacy, we ask you to hold those for a more private forum. Also, lastly, we are not lawyers, and this is not to be considered legal advice. Should you have any questions or before you take action, please consult with an attorney to make sure that this is the proper course of action you wish to take. We're just hopeful that we can give you more information to help guide you in making these decisions. So now I want to introduce one of my favorite colleagues that joins me, Paola Martinez-Boone from the New York Lawyers for the Public Interest. And she will be talking with us today about future planning. And so that constitutes a number of things in terms of planning. It's never too soon to start planning. And we never know what might happen to us or any day. I mean, you know, everything's going along and then a pandemic's here for 2 years. So we never know what's going to happen. So we want to be mindful of, you know, that possibility, and also just think however we can support our loved ones whenever we're not here should something happen to us. A few notes on Paola. She is the senior advocate and social worker at the New York Lawyers for the Public Interest. She's worked with them for the past 20 years and the last 18 as an advocate for the Disability Justice Program. She works on language access campaigns and on a number of other things, but she is a very well-known advocate here in the city, and she's promoting community outreach, community integration, and advocacy on behalf of individuals with disabilities. Paola, thank you so much for being here today, and please.
Good morning, everyone. Thank you, everyone who's joining us so far. This is the favorite part of my job. I'm not lying. I love to share information with you. I think that for you as a parent, grandparent, family member of a person with disability, the more information that you obtain, the better that you are equipped to advocate for your loved one with disabilities. My name is Paola Martinez-Boone. New York Lawyers for the Public Interest is the agency that I work with, and New York Lawyers for the Public Interest have been providing free legal services for about 45 years. We also well known in terms of disability rights in New York City. If at any time you believe that you will have an issue, legal issue, perhaps, want to be clear, because we are not a social service agency. We are a legal service agency. What that means is your issue have to be, you should be calling about legal problems. We are open. Use our telephone numbers on the first slide. Also, I will encourage everyone to look at our website. We have a lot of resources there. We have a lot of information. So please check our website. We are open for intake, meaning for interviews from 10 to 3, Monday to Friday. However, if you're busy, if you don't have time to call us during those hours, don't worry. We also have a link in NYLPI.org. Your help is right there. You just click it and we only ask you for your name, your telephone number, and what you're calling us about. If we're not the right agency, don't worry about it. We will give you resources, or we will give you a referral for you to call another agency that perhaps may be able to help you. We only refer to other nonprofits. We don't endorse any private practitioners. A note about the PowerPoint that I'm showing today, please share with others. The whole point about getting information is also learning and sharing information. So I'm happy for you to share this future planning PowerPoint. However, this is an intellectual property of New York Lawyers for the Public Interest. And therefore, if you're gonna share, you needed to share in the same format with the same information. You cannot alter anything in this PowerPoint. So I'm gonna skip a little bit about New York Lawyers, because once again, you can read it on your own. We not only do or have programs regarding disabilities, we also have a health justice program, and we also have environmental justice program. We have the Pro Bono Clearinghouse. So please go to our website, learn more about our agency, and feel free to call if you have any questions. On the disability justice program, I particularly work on their educational rights, meaning making sure that kids with disability have the right program, the right services, they have the appropriate education FAPE. So if you have any questions regarding special education program services, you're not in agreement with the IEP and all that, I did a whole presentation last week here at Synergy about that. You can look for that recording, or you can also call us if you have one of, special education issues. You can call our main number, and then one of us will call you back for a full interview. Once again, I'm gonna start right with the presentation. This is a very long presentation. I want you to think about when you're gonna ask me questions about the content. If you don't understand something about the content, happy to answer your questions. If it's a particular case that you have a situation, this is not the forum. We are on Facebook. And I don't want any of the personal information to get out. So I'm happy to answer your questions either in private. JC can send you my email. We can set up a time to talk to each other, usually minimum 30 minutes, and I will have all my attention for you. I will rather have you do that than exposing your name and all your life here in this forum. This is an open forum. Okay. Why planning? First and foremost, to preserve government benefits. So I don't see anyone. You see me, I don't see you, but many of you probably have still small children, or some of you will have adult children, 18 and older. Some of you, your child is still at school. Some of you, your child is already receiving adult services, via OPWDD, via voluntary agencies. The point here is that regardless of your situation, eventually you're gonna realize that in order for your child to receive extra services, you have to have Medicaid. Now, for those families who work and not eligible for Medicaid, there is the Medicaid waiver. And I'm gonna talk about the Medicaid waiver. If you have questions, you can call Synergy. But keeping in mind that all adult services, we call it adult services, but you can get it when your child is still small, are paid by Medicaid. So we need to preserve that public benefit. It's very important. We're gonna learn today how to do that. Also to improve the quality of life of the person with disabilities. In the past, many, many years ago, people with disability were only relying on public benefits. But now families work, they have income, they have other things that they could provide for their loved one with disabilities, and that is, a chance to improve the quality of life. Also to expand and not to limited choices. Because you have a disability, because you're a recipient of public benefits, or your child is a beneficiary of public benefit, doesn't mean that they only could have that and nothing else. If the family, once again, is able to provide extras, we need to know how can we have all that without interfering with public benefits. How do we start? Very simple. Many of you already have done this. If you have a care coordinator, if you are under one of the 3 major coordination agencies in New York City, you already have a life plan. You're already talking about the medical needs, the behavioral needs, social, emotional needs of your child with disabilities. So you're already talking about planning. This is not new. Possible actions. I put these possible actions because it's still, to me, is shocking that I talk to so many families and I ask them, okay, what's the plan? What's going to happen? And they said to me, oh no, I haven't done anything. I just, something happens to me, the sister will take care of, or the brother, or the father, or the niece, or whoever. And to me, I'm not gonna judge anyone on this, but I know it's coming from a place of fear most of the time. Fear of mortality. What's gonna happen with my child when I'm no longer here? And planning confronts me to that. So once again, I understand, I empathize, believe me, I do, but we have to plan. We have to do this. Once again, I keep bringing up government benefits because in the field that I move, government benefits is what the payer of every service I know in the adult service. Think about what you have. And this is important because I talk to families call me and say, oh, I don't have anything. And then when I talk to them, they say, well, I don't have really a savings account. My savings account doesn't have much, but I do have a life insurance. And I do have a pension because I work. And I do own this house. Okay, so you came from having nothing. Now we have 3 very important things. Who is the beneficiary in your life insurance? Well, this is my only child. So if something happens to me, life insurance goes to my child. Okay, how we tie that back to public benefits? So in reality, something happens to mom or dad, and the life insurance is $100,000. That means that child is gonna get $100,000. And I could tell you right now, that child is no longer gonna be eligible for Medicaid because now we have money. And we're gonna talk about how to do the same thing, how to have a life insurance, a pension, a house, but without interfering with public benefits. Okay, what's the process of future planning? I just put this together. This is not like the Bible, or this is just a place of reference. So these are the things, actually, this is more my agenda. This is the things that I'm gonna talk about today. So we're gonna go through all of that. So this is long. And I'm gonna go very fast. Let me start with the letter of intent. The letter of intent is not a legal document. And I want to be clear about that. It's not a legal document. That means it's not enforceable. But the letter of intent, the value of the letter of intent is that document is gonna allow you to describe the needs and the wants for your child with disabilities, the routines, what happens since the time that he woke up to the time that he goes to sleep, on weekends and all that. Why this is important? Remember, we're still in a pandemic. So if you have a child who has certain routine and you get sick, who is gonna be able to follow through that routine? Who's gonna be able to minimize stress for your child by helping him to do what he does every day? whoever you pick to share a letter of intent with, that person will have a map. That person will say, well, when, you know, when John comes back from school, I know he likes to play games. So I'm gonna have the games ready. And then he would like to eat and snack. And then he would like to, you know, take a bath, whatever that is. This is the document. We also need to include information about medications. If John takes medication every day at 8 p.m. and at 7 p.m., we need to know. So all those things are important, even though this is not a legally binding document. It's a roadmap for somebody who is willing and able to help you. So I will suggest for you and everyone to start doing a letter of intent. You can change it. You can change it. You can update it at any time. It's your document. You can send them people via email, mail, text, whatever, whichever way. It doesn't matter, WhatsApp, whatever. But the most important thing is that you need to share this document so somebody could help you when you need it, okay? So, because we're gonna talk about issues and decision-making choices, including guardianship, I always want to start with the definition as it relates to mental capacity. Because at the core of the decision-making plan and tools is mental capacity. Not everyone with a disability needs a guardian or a power of attorney of a healthcare proxy. So we need to understand capacity in order to understand if our loved one, what type of document, supporting document our loved one needs, because not everyone with a disability needs a guardian once again. Now, capacity is defined on the New York State law as everyone who turns 18 is presumed to have decision-making capacity. We call it adults, right? Everyone who turns 18 is presumed to have decision-making capacity. Now, who's an incapacitated person? An incapacitated person is a person who is impaired by reason of mental illness or mental deficiency to the extent that she or he lacks sufficient capacity to manage his or her affairs. We have a great deal of people under that bracket of incapacitated person. But then we have a lot of people not there, in need of support, and we're gonna talk about that. Who is the ward? The ward is a person for whom a guardian is appointed. Who is a guardian? A person who has been appointed by the court. And I want you to listen very carefully. When your child is steady and you call me and you say, I'm the guardian, the next question is gonna be, you went to court and you got a decision? And then you're gonna tell me, no, I didn't go to court, but I'm the mother and my child have, and then it comes a list of multiple disabilities that you list. Now, a guardian is a person appointed by the court. There is a process for this. I'm gonna learn about the process. Surrogate decision maker is any individual who is authorized by law or who is in fact making decisions for another. That's a surrogate decision maker. The Family Health Care Decision Act provides a process for a surrogate decision maker to make an end-of-life decision on behalf of someone who lacks capacity. So there you have different things that we need to start thinking about and understanding. How do we evaluate decision making? Now, here, I want you to think, if you don't know how to evaluate decision making, then we need to look at or to have conversations with people who have been working with our loved one with disabilities. We need to talk with the evaluators, the neurologists, the psychologist, the pediatrician, the doctor, so he or she have evaluated this child and could give you an idea of decision-making capacity. It's not one thing, it's a host of different things. So if you haven't done so, start looking at the evaluations, if you have an IQ already somewhere, that's also, it will give you an indication. So start looking at documents. When we get documents and reports from doctors, we're supposed to be reading them. We're supposed to give it a shot, even when we think we're not gonna understand them. Just read them. So how we evaluate decision capacity? Explore decisions individual has made or is facing. That's a way. Now, the second one is very important for me and should be for you as well. Balancing respect for the individual's self-determination and protection of his or her well-being. The word balancing here is on purpose because I want you to think as your individual disabilities. Once again, I don't know anyone in this forum, and look at that person as an individual and look at that person in what areas he or she is capable to make some decisions, in what other areas he or she cannot. Because we need to respect self-determination. There is a group in New York that is called, I think it's called self-determination. I actually think the group of self-advocacy, self-advocacy. And the people that belong to that group, self-advocacy, they're all adults with disabilities, which quickly tell you, I know I need supports, and I know in certain areas, I need people to help me, but I'm capable to make decisions about where I wanna live, what to eat, whether I want to take the subway or Uber, I'm capable of that. So once again, we have to balance out. The predetermination of decision-making capacity prior to an event presents serious problems. This means it's like, is decision-making time? Now I'm gonna try to assess whether this person have enough capacity or not. That's a problem. We need to be working on that way before that. The ability to give informed consent or to make a contract must be separately determined. Meaning, once again, we're now at the right here. Oh, please put your signature here. Not a good thing. We need to already have done the work to determine capacity and not to wait until we are thrown in a situation and to start signing without knowing what we're signing. Okay. A person may be competent in one area and not competent in another. And this is really important. To my example, self-advocacy group. Competent in many areas, many not that competent in others. But we have to respect that, but we really have to understand. Okay, components of decision-making capacity. Ability to communicate a choice, ability to understand relevant information. Once again, this is not like an exhausted list. It's just to give you an idea. So if you haven't realized this, you start thinking about it. Now, for many of you, I understand it's clear that you shall have not mental capacity. I have families that call me and said, my child is 20, but his mental capacity is 24 months. Of course, we know that person doesn't have capacity. But once again, it's not the case for everyone, because a child have a disability or they'll have a disability doesn't mean that they cannot make any decisions, okay? So we have to be careful about that. I mean, this decision-making domains is really, and showing you examples of, what are the things that we always make in decisions: living arrangement, work, training, personal, all that. Okay, so now that we got out of the way decision-making capacity, now we're gonna talk about certain legal documents that we need to understand. Even, please bear with me, even if you feel this is not relevant to you right now, because I'm gonna tell you, you never know if they're at one point gonna be relevant. So I'm gonna start with a regular trust. This is a trust, a regular trust. A trust is a tool that we use, someone uses to leave money to somebody else. Okay, that's really the basis of the trust. The information is there, you can clearly see the legal part, but basically is a tool used, someone, usually a parent, a grandparent, an uncle, to leave money to somebody else. That is a trust. And now in that trust, that grantor, the person who's giving the money, could put cash, could put stocks, bonds, property, and some other types of financial assets. So that's really a trust. Now, the most important piece here that I'm showing you is that in the bottom, the red words. Grantor is the person who's giving the money. Trustee is the person managing the money. And beneficiary is the person receiving the money. Now, the grantor and the trustee could be the same person. If you are a parent, most parents are also the trustee of the trust. Now, if the money is coming from my aunt, she might just say, you know what, I just want to give money to John, you take care of the rest. So aunt might be the grantor and the trustee, the manager might be mom. Now we're gonna transfer to the trust that is specific for our population, supplemental needs trust. So the supplemental needs trust really works in terms of most of the rules of the regular trust. However, the beauty of the trust fund is that preservation of public benefits such as Medicaid. And this is why our population need to learn about trust funds. Still important things about the trust fund that you need to learn is irrevocable, meaning you cannot change it. And it's discretionary, meaning the trustee, the manager, have authority to refuse or make distributions. That means that I'm the manager of the trust and the money comes from my aunt, and my aunt comes to my house and said, oh, I gave you money for Johnny, and I see that he needs a new bedroom set. Even though she gave me the money, but I'm the trustee, I have authority. And I said, no, aunt, I think that's fine. The one that he has is still working because I have all the authority as a trustee. So that is important to learn. In terms of the supplemental needs trust, we have the first party trust and we have the third party trust. And we're gonna learn about those two. So the first party trust is funded, meaning the money, the cash, the access, the bonds come from the person with disabilities. Now, every one of you now is thinking, but how my son is, from where my son is gonna get money? He has, you know, he's on public assistance, Social Security. I don't know what this means. So how can your child with disabilities get money? Lawsuits. So when something happens to your child, a car accident, medical malpractice, whatever is going on, that his name is in a lawsuit, when he received that money, or in the process of receiving that money, then a first party trust should be established to protect Medicaid, to protect those public benefits. So that's the part that I want you to learn. Any one of you who is in the process of suing someone because something happened to your child, think about first party trust, please. Because this is the way that you're gonna make sure that your child has money saved in a first party trust plus still recipient of Medicaid. Once again, because Medicaid is the payer of adult services. If your child is gonna end up in any of the voluntary agencies receiving day help, rehab, and all the other services, Medicaid is the payer of that service. So you need to preserve eligibility. And how do we do that if we sue someone? First party trust if your child is involved in that lawsuit, okay? So very important to learn. The other type of trust, special needs trust, supplemental needs trust, is called the third party trust. And in this trust, somebody else is giving the money. In the example that I presented, is my aunt gave me the money to put a trust together. She's the grantor and the trustee, and my son is the beneficiary. That is called a third-party trust, meaning the money didn't come from the child or the person with disabilities. It came from a third party, okay? I could be the third party also. Let's say it's my money. Let's say I'm the one who have the life insurance. I'm the one who have a pension plan, and I want to leave part of that to my child with disabilities, then I will still create a third-party trust. Now, keep in mind that when we're talking about trust funds, we're talking about a lot of money. We're not talking about, oh, I have $10 extra or even 1,000 extra, and let me put it into a trust. It's not worth it, and I'm gonna tell you why. Because the trust is expensive to set up. If you know you're gonna leave a lot to manage, hundreds of thousands, yes, the trust is the place. Or even 20,000 perhaps, maybe, just because eligibility to Medicaid. But think about it. And I will suggest for you to look for an attorney who practice in this area to explain to you, if you come into money, what to do in terms of your case. It's case by case. It depends, you know, how much you put it into, and also at the end of the year, you need to do the accounting for the money, either in the third or the first party trust. Let's say if you open a third party trust because you were one of the winners of the lottery last week, and you put $1 million here, then if you spend some of that money at the end of the year, you need to account for it. If now the record says that, you know, you put $1 million last year, but now it's $900,000, you need to account for the $100,000. So once again, it's important. You need an attorney to set it up. We don't do it at New York Lawyers for the Public Interest. It's not in our area of practice, but there are plenty of private practitioners that they put this together. The same rules apply, irrevocable and discretionary, and you need to take that into account. Irrevocable means once you establish the trust, you cannot change it. Discretionary means the trustee, the manager, have the authority to make all the decisions. Okay, so now we're gonna move from the trust to another tool that you can use. Let's say you're not in that group of parents that have hundreds of thousands or paying for a life insurance or own a house or have pension plans, but you still want to put money aside for your loved one with disabilities. By the way, none of the money that you put aside can be Social Security money. I want to clear that. You cannot save in any account Social Security money. Social Security money is to be spent, and that's how we're supposed to do it. So what is a 529A account? A 529A account is called the ABLE account, and it's also an account that you can open to put money aside for your loved one with disabilities. The beauty of this account is you don't need an attorney, you don't need representation, and you can put up to $15,000 a year to the maximum of $100,000. So with this in mind, how can we open a 529 account? These accounts are opened by New York State Comptroller's Office. At the end of the presentation, you will see the link to their website, their telephone number. They open the accounts, and they will help you with information about the account. They have pages and pages and pages about this account on their website, or you can call them and ask questions. Once again, this is another way to put money aside, less money aside. It's still worthy if you want to put money aside, and it's still your child will continue to be eligible for Medicaid, which is the payer of adult services. Okay, now we're gonna go right into decision-making options for people with disabilities. And there are many options because one size does not fit all. And because once again, because a person has a disability, doesn't mean that they need a guardian, which is, as you can see here, the most restrictive choice, the most restrictive option. So the less restrictive, obviously, the person maintaining, person making their own decisions. With support, you can still have mom there helping you along the way, but they still want to feel that ownership because they're capable to make decisions. Then we have the healthcare proxy, power of attorney, and support decision-making. And once again, guardianship, most restrictive. I know it will be fine for many of you, not for all. I am not the guardianship police and do not tell anyone to do a guardianship or do not do a guardianship. That's not what I do. What I do is to give you information and choices. So you know, besides what other people are telling you, that guardianship is not the only option, and there are other options besides that. Then we have surrogate decision making, and we have the power pursuant to the Family Healthcare Decision Act, which I talk about it early on in this slide. You can go back and see the definition of that one. Okay, let's start with the least restrictive. Healthcare proxy. Now the healthcare proxy is not specific for people with disabilities, for anyone. We all should have a healthcare proxy, especially in these difficult times of a pandemic. And people with disabilities can have one. The most important part here is that that person must have capacity. So if you already called me and told me that your child is an incapacitated person, then you cannot turn around and say, but I am looking for a healthcare proxy, because that information contradicts. In order to have a healthcare proxy, you have to have capacity. How does it work? Allows the individual to appoint an agent. So if I'm a person with disabilities, I could appoint my mom as my agent in my healthcare proxy. When it takes effect, this is important. When you have a healthcare proxy, it's not like you go to the doctors and then you're signing for that person. No, it only takes effect after 2 doctors decide that a person no longer has capacity. So once again, this is not the way out for doctor's appointment or for dental appointments, because this is very specific for situations in which it's determined by 2 doctors that a person no longer has capacity. So we need to keep that in mind. All right, it's very important to have one, but we also need to understand the document. Another one is power of attorney. Another one that the person must have capacity. And we need to be clear about that. This person must have capacity in order to sign an agent. Now, recently in December last year, there were some changes to the power of attorney. Now we have 2 types of power of attorney. One is called a springing, and that one names an agent in advance, but that person doesn't have any legal authority until the principal, meaning the individual, becomes incapacitated. So we can go and do a springing power of attorney, but it's not active until the person becomes incapacitated. And then we have the traditional durable power of attorney, in which becomes in effect immediately. Now, once again, important piece here, the person must have capacity. I actually got a call from someone yesterday, very confused, not to her fault, but this is what we're dealing with. She already is the legal guardian of her child with disabilities, profound disabilities, and she went to the bank to change an account, and then they're asking that her daughter signs a power of attorney. So obviously the bank is not understanding these documents, because if you're already the guardian of a person with disability, you already have those powers, number one, and you already deemed proof that the person doesn't have capacity. And power of attorney requires capacity. So obviously the bank is confused. They don't understand. So that's important for you to understand, so you can talk to them about it and even bring information to them. And if the teller doesn't have a duty to understand all this, well, I take that back. They should have a duty to understand all this, but I assure you probably is not in the list of priorities. So you talk to the manager, you talk to the branch, or you talk to the headquarters. Somebody along the way, those banks have a lot of attorneys on staff, need to be able to understand what you're trying to do here. But once again, for power of attorney, you have to have capacity. If you already have guardianship, then you don't need a power of attorney. Okay, supported decision-making. So in the beginning, I talk about there are other options as well, besides power of attorney, proxy, then we have supported decision-making. Supported decision-making is not a legal document. However, it's a process in which the individuals who work in the supported decision-making kind of evaluate the person with the disability, not evaluate in terms of a neurological evaluation, none of that. Evaluate in terms of they talk to the person, they see, you know, how they make decisions, how they analyze things, and then they draft basically a document. They draft a document so you will know in what areas your loved one will need more assistance, and in other areas they need less assistance. So this really, the information for the people who don't support decision making is also at the end of the PowerPoint. Once again, you can click on their website and learn more, or you can call them as well and learn more about decision making, to see support decision making, to see if this is maybe perhaps something that it applies to your child. Or to I call him child, but this is all for people that, you know, adults, 18 or older. Okay, more restrictive, but it says this is good for you to know so you don't get scared if you haven't done guardianship, or you haven't done any documents. Is surrogate decision-making committee, because in the case that a person, you know, you have an incapacitated person, but you haven't done guardianship, you haven't done anything, and this person needs help approving, for example, certain medical procedures and all that, and the doctor looks at you and says, well, this person is an incapacitated person who has the guardianship, and you say, oh my God, I never did that because I was overwhelmed, confused, or I didn't know. They will say, well, then what's going to happen is for this particular treatment, then we need to submit a request to the surrogate decision-making committee, and they will answer us in 14 days. And you will get an answer, and that will be an answer for that particular procedure. It's not permanent, it's not all the time, it's just for that particular procedure. So it does exist, and you know, if you don't have anything in place right now, please don't panic. You can still utilize this if that is the case. And mostly the people who are treating your child, they know about surrogate decision making, so they're gonna bring it to you when needed. We already talked about this in the beginning, but it's there to read. Then we're gonna go to the most restrictive, which is guardianship. Once again, a guardian is someone appointed by the court. It's a court process. And you can become the guardian of the person, the guardian of the property, or both under the guardianship. Now, there are different types of guardianship, and I want you to be aware of that. I actually spoke with someone about this yesterday. For example, if you are following Britney Spears' case, I'm particularly not a fan of her, but I've been listening to it because of the guardianship piece. The type of guardianship that she has is not Article 17A guardianship. So under Article 17A guardianship, they are very specific for individuals with intellectual disabilities and developmental disabilities. Now, if by now you don't know what is an intellectual disability or what is a developmental disability, I think it's time to learn, because it's very particular. If your child have anxiety, this is not a guardianship for that child, okay? Intellectual disability used to be what we call BAC, mental retardation. That terminology is old, out of date. We don't use that anymore. But to give you an idea, that's what an intellectual disability is. Developmental disability is a whole list of developmental disabilities, autism, cerebral palsy, neurological impairments. This guardianship also includes traumatic brain injuries. So now, for you to apply for this guardianship, you must have the documentation that supports intellectual disabilities or developmental disabilities. Please be clear about that, because I have a lot of parents who are confused. I have parents who the kid's diagnosis is ADHD, attention deficit disorder, and they're calling me about guardianship because they don't understand that it's not a developmental disability. ADHD actually is a neurological, and most kids with ADHD, most people don't need guardians. But anyway, that's a different conversation. But once again, to give you an idea. Now, for Article 17A specifically, you don't need an attorney. It's paperwork. You need to fill out forms. And I want to make sure you understand it's plural. It's several forms. It's not one form. It's several forms. They are online. You have access to them online. You can review them. The core system have put something called do it yourself. Now, Synergia is going to send you along with this presentation, another presentation is with the specifics of guardianship. So I would suggest for you to look at that. It's a core proceeding. This is very important. Guardianship is not only paperwork, but it's a core proceeding, meaning once you submit a request for guardianship, you're going to have a court day. You're going to be fingerprinted. They're going to look at you to see what kind of character you have, if you have federal offenses, if you have misdemeanors, or if you committed a robbery or whatever, all that is gonna be looked at, because what the court is looking is that who's gonna be the best person to continue taking care of this individual who's vulnerable, who is a good fit for this person. So once again, they're gonna fingerprint you because they're gonna find everything about you. And I want to be clear about that. And, you know, also with the purpose of see if you are a good fit to be a guardian of this person. In the past, we're supposed to be submitting petitions in person. With the pandemic, I don't know if anything has changed. I have the contact information here for you to contact the court with questions regarding their process. Okay, and the information that I have is only for the 5 New York City courts, surrogate courts. I don't know about Long Island. I don't know about Westchester. I don't know about upstate New York. So the information, this information that I, in terms of the surrogate score, is only for the 5 boroughs. Under the guardianship, Article 17A, you are allowed to have a guardian or guardians, meaning 1 or 2 individuals. The thing with co-guardianship, if you both need to be in agreement, and you also need to sign the contracts and documentations together. It's not like, oh, my husband is the co-guardian, but now he's in a tour in Africa for 6 months, and he's okay with me signing. Doesn't work that way. Both of you have equal authority. And I'm going to give you an example because sometimes we don't see the relevance. I used to have a couple that did the guardianship when they were married, and then they divorced, and it was a huge issue because they cannot agree on anything. So they end up going back and, you know, hire attorneys, and it was a whole big deal to reestablish guardianship. Okay, so keep that in mind. So you can have guardian or guardians. Then you can add a standby guardian, first alternative, and second alternative. You don't have to have all those individuals. You have, you know, if you only have a guardian, that's fine, you go for it. But if you have a standby first or second, you can actually put them there. They do nothing until something happens to you. You become incapacitated or die. Then they have, I believe 120 days or 90 days, something like that, to go back to the court and said, this person is no longer, it's not, you know, this person passed away. I need to, you know, now take the guardianship, and they're gonna give that standby guardian some forms for them to fill out and for them to submit. So it's not automatic. That person needs to show up. So let's say the standby guardian passed away before even the guardian, then the first alternative can show up and in the same order, or the second alternative. Now, if you put a standby guardian who was your best friend, but now you hate that person, I get those calls, by the way, too. Then you go back to court and say, you know what, my best friend, Mary, I don't like her anymore. I want to take her out of the guardianship, and the court is going to tell you what to do. Okay, once again, 5 boroughs surrogate score, New York City. I don't know what Staten Island, I'm sorry, Long Island is doing, but I know that New York City have procedures for that. Okay, the other guardianship, Article 81 guardianship, probably similar with what Britney Spears has. And you can see in terms of the whole movement about her is because guardianships are very limited. She's not able to pick up even the cabinets of her kitchen, the color, all the way to major decisions in terms of her financial decisions. So that's what guardianships do. 81, by the way, is a little bit more flexible, believe it or not, and it's tailored to the needs of the person with disabilities. So this Article 81 guardianship, it does require an attorney. It's a court process and it's very expensive, just FYI, okay? If you want to go for it, fine, but just FYI, it costs a lot of money. You have to hire an attorney. The court assigns an attorney for the person with disabilities, and then you pay for everything from the submitting fees all the way to evaluators and or everything else that the court needs. Okay, so once again, reasons to pursue guardianship, because we know and I understand that there are many individuals with disabilities, because of the severity of their disability, they cannot, do for themselves, they cannot pick the appropriate services and all that. So I get it. So that's one of the reasons why a person will need a guardian. And reasons to avoid, once again, if we want to balance respect for the person's self-determination, if they have that capacity, and protection, then, we probably be here in the midway. But once again, that's an individual decision. That's a family decision. I don't tell anyone what to do. That's not my job. My job is solely giving you this information so you know now what exists out there and what decisions are going to be best for your own family. I want, once again, to remind everyone, if you have personal questions, please email me and I could coordinate a time to talk to you. More than happy to do so. If I don't want personal information to be in this forum, we are live in Facebook. This is a recording, not appropriate, okay? But in general, if you have questions about the content of the presentation, go for it at the end. These are the surrogate court locations and telephone numbers. Once again, I suggest for everyone who's gonna start this process to call the surrogate score and ask them what about their resources and specifics about how to file, when to file, and all that. A reminder, if you are looking into guardianship, is that what is appropriate for your loved one with disabilities? This stuff starts at 18. If your child is 5, this is not appropriate. You are the biological guardian. Well, I wouldn't say biological, right? You're the guardian if you adopted the child, gave birth to the child, and went to the family court, you are the guardian. This is for adults. This is not for children. This is for adults. You can start the process more or less 17 and a half, just because the forms from doctors and from everyone else that you need to support your petition, they're only good for 1 year. So you cannot be, if you're a planner like me, oh, my child is 15, let me start now. Nah, it's not gonna be good just because this is, the forms have to be a year old. So 17 and a half, pass a little bit 17, you can start filling out the forms, getting, accustomed to the language and all that. And then when it's closer to the 18th birthday, then you will bring the affidavits from either 2 doctors or 1 doctor, 1 psychologist to fill out attesting that in fact your child lacks capacity, and they're gonna give their reports. the resources that I was talking about. Surrogate decision-making link is here, telephone number, guardianship, everything is here. Other agencies, the ABLE plan, I put it here, right here. If you're interested in putting money aside that way, that's the information there. With that, this is the end of the presentation. So thank you very much for attending. And now I think JC is gonna open the lines.
Hi, yes, thank you so much, Paola. And yes, we do have a question. There was a comment earlier about autism and autism being an intellectual disability, and that is correct. Autism is definitely
Yes.
an intellectual or developmental disability, and certainly recognized by one on all levels, federal, state, and local.
Before you move on, JC, in terms of autism, yes, it is a developmental disability, but once again, it depends on the mental capacity of that individual. And I'm gonna give you an example because sometimes we live in the bubble and we only seeing our loved ones. But for example, Elon Musk have autism. He disclosed that he has that, and he's the owner of Tesla. So if you're Elon Musk, I assure you, you don't need a guardian. However, if you have a child with severe autism and other things, maybe, yes, guardianship may be appropriate, I don't know. But once again, I want to think about autism as the spectrum it is.
Yes, that's a very good point. And you know, as the saying goes, you've met one person with autism, you've met one person with autism. Everyone is different and it goes based on needs. But yes, but thank you. And thank you for sharing that. I didn't know that about Elon Musk. We will be sharing Ms. Martinez's email in the follow-up email. So I'll be sure to include that. There is a question here. I ordered to do a trust. How much is the cost? Do you know how much it costs to set up a trust?
It depends. You need to find an attorney, and it depends how much is gonna go into the trust. That's the other part. That's why I was talking about it costs money to create a trust, but you also have money to have a trust. So it depends. And I'm gonna give you an example. If you don't have liquid cash, and we're talking about life insurance, pensions plans, but at the same time you own a business and you have stocks and you have that is a lot to put into a trust in theory. So many times even the attorney end up telling you, well, we also need an accountant because we need to hire an accountant to manage this, you know, all these different things that you're putting into the trust. So that is going to cost much more than a basic trust that is a parent saying, well, I work, I have a pension plan, something happens to me, 20% of my pension plan is going to go to my child with disabilities, and I don't want to interfere with Medicaid. Therefore, you know, this is the only thing that I have that I'm going to put into it. And that brings me to another point, that when we are young and strong, and I don't see anyone, and I assuming you're young, strong, and beautiful, we don't think about ourselves needing planning. So I hear so many parents when in the 30s, 40s, 50s, everything I have is going to be for my child with disabilities. Keep in mind, the trust is irrevocable. So if you put everything that you have in that trust, then when you turn to be 80, and I don't know about you, I'm not 80 yet, but my knee start hurting. Some of that money I'll need for me when I'm in that stage. So once again, when you think about planning for your child, think about planning for yourself, because we all gonna get there one day, okay?
That's a good point. Yes, great presentation. Thank you so much for your presentation today. It's been very informative. Yes. All right, well, if there are any more questions, please ask them now. Otherwise, we're gonna give you back some of your day. Thank you so much for making time for us and for this presentation. It's so much to learn about, and we will be sharing the PowerPoint and the recording to this, as well as Paola's email. In that, I will also include the presentation that we've done with Cuddy Law, which is a law firm that works in special education law. We did a presentation on guardianship and alternatives. And also the supported decision-making option that Paola was talking about, not to be confused with surrogates, but supported decision-making.
Right.
Is a movement that is growing here in New York State and across the country that isn't as restrictive as guardianship. It doesn't take all of those rights, but again, it's something that you need to know is if it's right for your individual, your loved one, and consult with an attorney to see if that's a good option for you. But we have a presentation by the organization that's pushing this movement, which is Supported Decision Making of New York. And those are both about an hour-long presentation, maybe even shorter. But they're very informative and they go in more depth into those specific types of legal aspects of transitioning into adulthood.
Daisy, did they present it already? You have them on record, or they will be presented?
I do, and we will be presenting, Cuddy Law will be back with us in December or January with updates, any updates that we have, but yes.
Can you send me this, the decision making, the one that you mentioned as well, that recording, if you don't mind?
Yeah, absolutely, absolutely. We do have a question. What about just life insurance for a trust?
Well, once again, depending how much money we're gonna leave behind. If it's a life insurance that, and I remember back in the year, no, I don't even know if this is a thing, but back in the year, people called me about the Gerber life insurance. Like at the hospital, I guess they used to sell then, but it really wasn't a lot of money. Now, once again, what we need to look into is Medicaid eligibility. And right now, to be eligible for Medicaid, if you are on the waiver, they're not looking at the income. However, when your child turns 18 and you need to establish eligibility via there being a person with a disability and being 18 years of age, they're gonna look at whatever he or she has at that time. If something happens and you have a life insurance, and the life insurance, for example, $20,000, perhaps that's not a lot of money to put into a trust. But if you don't have anywhere to go, if you don't have a person that you trust, then of course go for it. So, but once again, it has to be some relevance to how much money you're gonna spend putting together a trust in terms of how much money is gonna go into the trust. Now, if you have a life insurance, for example, that if something happens to you, your child is gonna get $500,000, of course, I will say run for the trust, go do it, because that definitely is gonna keep out your child of public benefits. But once again, whatever your child have in the account at the time that they are applying for Medicaid, that is what is going to be account. Medicaid and Social Security, they have a very, very specific table that they follow in terms of eligibility, and they're not flexible. So let's say if your child, you open a bank account for your child and you put their money for their birthdays, their first communion, the this and that, and you turn 18 and you try to go eligibility and you look at the bank account and they say, oh, oops, it's $20,000 there. Medicaid is going to look at that as income, child's income. So once again, the point that I want to make here is the one that I did in the first slide, preserving public benefits. And you need to look into the rules of those public benefits. That's my other tip. We need to understand the systems that we are involved in. And public benefits is one of the systems that I beg you to read, to understand, to go to the Social Security page, to Medicaid page, CMS page. Please learn about those systems, because that's how you're gonna maximize benefits for your child, okay?
Yeah, and preserving those benefits is so important, especially once you're not here, and something that you've, as Paola just said, it's something that they're very strict with. They're not very flexible at all. Like, I mean, they have no problem denying, issuing denials, and to contest it is such a pain, really.
Right.
So yes, I mean, and there are some individuals with disabilities that are able to work even once they're adults, and they're able to preserve that income and still preserve their Medicaid benefits, their public benefits. So there are ways to do it. but you do have to kind of get your hands dirty and become familiar with a lot of detail, a lot of granular.
Absolutely, absolutely. Take any workshop about public benefits that you see around, because the more that you hear about, the more that's gonna stick with you, and the more that you're gonna realize, oh, this is what I need to do, and this is what I need to prepare for, all that.
Yes. There's a question. Is it true that the state starts looking back at income as far as 15 years old for Medicaid or Social Security?
My office does not do public benefits, so I don't know, but I won't be surprised.
I wouldn't be surprised either. We don't work with public benefits either in terms of that aspect, but yes.
It could be, because I remember that back when I took my last benefit workshop 10 years ago, they always said that the state always asks for records 3 years back. So if your point is that when your child is 18 and you start the process for him to be eligible for Medicaid and Social Security, it makes sense that, you know, they will look at what he had when he was 15.
Yeah. There is a question. How do they know if it's a public benefit?
I don't understand the question.
Ms. Burwell, would you like to come off of chat? Will Synergia do a webinar on public benefits? I'm not sure, but actually I will put it down as a request, a suggestion, because I think that's something that we could all benefit from learning more on.
Me too.
we definitely do a workshop on connecting with OPWDD and the front door process for people with intellectual and developmental disabilities. But as for public benefits itself, in general, I can't say that we have, but I will write it down and make sure that we can try and do something on that. So stay tuned. Let me see. I'm going to let Ms. Burwell ask a question. Come off of speaker. Hold on. Ms. Burwell, if you want to ask your question, go ahead. Come off.
Okay. Hello.
Hi.
Yes.
Hi, thank you.
Hi.
Hello. Hi,
Yes.
thank you. Okay, I have a sister that she's on disability and she likes to save her money, and she's saving it into my grandson's account. So that's why I'm trying to say, how do they know that's public money if she's not working?
Okay.
Well, because they're gonna look into the source of her income. Her source of the income is Social Security. Is that what you're saying?
Yeah, she's on.
So how she's saving money? Okay, let me back up a little bit. I'm gonna back up a little bit, because this is what happened. The rules of Social Security and Medicaid are so strict, and they look into everything, and they're very intrusive, because these benefits they were created and they was called means tested, meaning that when you submit that application, they're gonna look at your needs and what you have or what you don't have, and that's why you need those benefits. Now, keep in mind, and I have to confess this, I'm an immigrant myself. I didn't know anything about benefits when I came to this country, and I thought that the United States was a great country because they give you money to some people in need and they give you checks. Now, I've been here long enough, I could tell you that the rules are so strict because these are taxpayers' money. The government in the United States is not giving away anything. That's why right now there's this thing about Congress signing to give millions of dollars to Americans, because it's taxpayers' money. So coming back to your question, right? How that relates is because the Social Security and Medicaid is taxpayers' money. And if when your sister applied, she said, I don't have anything and I have a disability, I need this money, they're gonna look and say, but how she's saving money? How she, from where? What is the source of what is the source, right? Now, the other part of this is if we're dealing with government agencies, and I have to say this once again, this is not a judgment call for anyone in this forum. However, I myself have gotten calls for people who have utilized Social Security money to save and to transfer and to do this. And then 10 years after, they receive a letter from Social Security money and said, we've been looking and we're checking, and now you need to give us that money back. Okay, so once again, sometimes they take a lot of money, but let me say, and this is a very bad example because we're dealing with that, and this young lady who was murdered and her boyfriend is missing. In the United States, you can kill someone, you go somewhere and you are missing for years, they don't find you. But if you owe money to one of those government institutions, they will find you.
Okay.
So
Right.
once again,
uh-huh.
once again, I don't know if they're ever gonna, keep in mind, Ms. Lewis, you are the perfect example of this question should have been private because we are a legal organization. We are legally right things. Once again, don't know anything about what you're saying or whatever, but once again, we are a legal organization. Legally, I tasked to tell you how things are. In terms of programs, in terms of services, in terms of how Social Security, all that, that's my job. Right,
but let me ask you one more question. Is Social Security and SSI different? Because Social Security is the money that you put in.
There is, once again, I hope Synergia does the Social Security stuff because the big is the Social Security Administration. Under the Social Security Administration, there are several programs. One of them is the Social Security, one is SSI and the other one is SSDI. So under SSI is the money that people who work put into the system. And then when we retire, we're supposed to get, some check, allegedly. I don't know if we're gonna get it, but allegedly we're supposed to get some checks. And SSDI is a pool of money that is for people with disabilities. But once again, it comes from Social Security Administration, which is taxpayers. Because remember, government, they're not companies, they're not profit. So the government is not making profit. They're collecting taxes to give to programs and services. And at least I know my country doesn't do that, but I'm glad that this country at least have some systems that provide some protections for people with disabilities, for the elderly, for the poor. But that comes from taxpayers' money. It's not free. So that's why you're seeing, if you turn on your TV to the news, all that you're gonna see is how our president is trying to, sign some money distribution, and Congress is saying, no, it's too much money. Why? Because they're looking, it's taxpayers' money.
Oh, okay. Thank you.
Hope that
You're
helps.
welcome.
Thank you so much for your question.
Once again, to clarify, Social Security money is not to be saved. It means tested, meaning that when you apply for, in your forms, you said that you needed, because you needed to eat or you needed to buy clothes or whatever the list of things that you can utilize Social Security for, that was there for. If you are saving your money, Social Security money, you're giving the idea that you don't need that money. And it's not free money, please. And once again, I'm from a legal organization. I'm sorry. I don't want to offend anyone, but this is what I'm supposed to do.
So yes, and the question, so you cannot save a child's SSI money. Because SSI recently asked if I saved. Yes. Yes, that's exactly what
they're asking.
All right. Well, yes, for those of you joining on Facebook that would like a copy of the PowerPoint, please email me at jcortez@synergiany.org. I will also post that information on in the comments section on Facebook. And yes, everybody who's attending via Zoom will receive a copy of this presentation and a hyperlink to the recording. I want to thank Paola again for joining us today. If you know
Carl.
somebody that speaks Spanish, tomorrow we'll be doing the same presentation. Sometimes it's just better to do things in the person's native language. And this is such an important topic that we want to offer it in that specific way. So yes, if you know somebody, we'll be here tomorrow, same time, same place. You can find it on our calendar. Oh, I see a question. This was wonderful. Thank you so much. We really enjoy your feedback. Yes. With that, I want to leave you with a poll just to let us know how we're doing. Other than that, thank you so much. We're happy to also give you back 10 minutes of your day, but thank you for joining us. Have a great day.
Thank you so much. It has been my pleasure. Bye.
Bye-bye.